Hi, everyone. Welcome. Before we begin, I just want to share at the top of the call that we are recording this session for distribution to those who could not attend today. Therefore, we do ask that you keep your cameras off, and I believe we're actually in webinar setting, and so you should not have that option. However, you should have the option to connect with us via chat. So please feel free to just shout out where you're streaming in from in the chat box, and we'll be sure to shout you out. But feel free to share your city, your state if you wish. And honestly, you also don't have to write in the chat box either. Completely up to you. But we welcome everyone from California to Georgia, New Mexico, all over the country. Thank you for joining us. Queens, New York, Charlotte, North Carolina, amazing. I'm actually streaming in from South Portland, Maine today. So I'm in a different spot than I usually am. But I love to see everyone gathering us. So my name is Kenyora Parham. I am the Executive Director of NRAPE on campus, and I am joined by my colleagues and partners in this work, Tracy Fitchers, Executive Director of It's On Us. We want to thank you all for joining our virtual town hall today. And Tracy and I have been doing this now for the past 2 years. This is our third Title IX hall, where we're back to essentially provide folks with an official status, update, and breakdown on Title IX regulations. So as a reminder, we are recording this session. And so if you have any concerns about privacy, feel free to use a pseudonym, or any questions you have, feel free to directly message us. But before we start, we first must acknowledge Friday's SCOTUS decision on Roe versus Wade. NRAPE on campus and It's On Us, we remain steadfast in our belief that abortion is essential health care for all people who can become pregnant. And we also know that access to abortion and other forms of reproductive health care is critical, not only to survivors of sexual violence, but to all people, regardless of their identities. So we will keep fighting for abortion access. And you can turn to our organizations for support for both now and in the future. So last week, also, in addition to that news, the Department of Education officially released the draft of the Title IX regulations and the notice for proposed rulemaking process, which I'll explain a bit further in this town hall. So to give you a rundown of what to expect during this town hall, I will provide you a bit of that context as to how we got here, and Tracy will provide you with a breakdown of the proposed Title IX rules and what these regulations mean for survivors and campus administrators. And then I'll provide you with a rundown of what we have coming down the pipeline with regard to our calls to action. So before we begin, I just want to say to everyone on the call that while we have what we may have is great and hopeful news, we also know that the Title IX regulations and the process around it as a whole has been triggersome for a lot of folks, especially as we've been waiting in this regulatory limbo for some time, and students are still looking for answers. So at any point throughout this town hall, if you feel that you need to step away, please do not hesitate to do so. And if anyone or some of you know needs immediate support, know that hotlines are still open and you can call on some of the following hotline numbers that I just placed in the chat for you. So additionally, we understand that some of you may want to share your story via chat. And if we do, we ask that you share your stories directly with the hosts of this call or after the call at EROC@civicnation.org or contact@itsonus.org. The point of the call is to share information of the Title IX regulations and ask you to join us to take further action, this time with the Department of Education, to ensure that your voice is being heard. We don't want to cause anyone to be triggered by another further perpetuating harm. So any kind of Zoom bombing or threats or anything that is not ideal in this space, we will remove you. So we don't take kindness to any type of vulgar profanity or any harm that's being done in this space. But we thank you for your presence and we thank you for being here. So for some background, Title IX is a federal civil rights law that requires any K through 12 school or institution of higher education that receives federal funding to uphold gender equity in their policies and practices. Since the Clinton administration, Title IX has been interpreted to provide protections for students who experience sexual violence. During the Obama-Biden administration, guidance was issued by the Department of Education in 2011 and in 2014, clarifying for colleges and universities their responsibilities under Title IX to prevent and respond to incidents of sexual violence. That guidance strengthened student and survivors' rights. Yet unfortunately, in 2017, Secretary of Education Betsy DeVos rescinded this guidance, and in 2018 put forward her proposed rules to change Title IX. More than 120,000 people submitted comments on her proposed rule changes, with the vast majority opposing the dangerous changes. Sadly, she made that decision to move forward with issuing them in the summer of 2020 during COVID. Fast forward to March 8th, 2021, under a new administration, President Biden, where he issued an executive order directing the Department of Education to both the DeVos era Title IX rule and any related guidance, technical assistance, and or documents addressing issues of sexual harassment, including violence in educational institutions. The executive order directed the department to complete this process within 100 days. The Department of Education responded by publishing a short blog post on their website stating that they would begin executing against the executive order immediately. And in April of 2021, they announced those next steps that they would take to fulfill the executive order. In June 2021, the Department of Education held a virtual public hearing with student survivors, advocacy organizations, administrators, parents, and other stakeholders to obtain feedback on the existing Title IX rule. The public hearing took place virtually over the course of multiple days. In July 2021, the department issued a Q&A guidance document on the, in effect, the current DeVos Title IX rule, with the goal of helping colleges and universities to understand that they have discretion in the application of the rule, and in turn do the least harm to student survivors and campus safety while the rule is still in effect. So for example, under the current rule, schools have the option of choosing between a preponderance of the evidence or clear and convincing standard for adjudicating Title IX cases. And what we feel is that schools should be using the preponderance of evidence standard as it does the most to support student survivors in achieving justice, and is the evidentiary standard for literally every other type of student misconduct investigation. That Q&A document helps schools navigate the existing rule and to do the least harm possible while it was still in effect. Yet, as we know, as students were transitioning back from virtual learning to in-person learning, there was an exacerbation of sexual assault incidences. And that took place at the start of the school year in what we've deemed as the double red zone. The red zone specifically is the time between where students arrive to campus all the way through Thanksgiving break, when more than 50% of sexual assaults occur. And because of that transition from in virtual learning to in-person learning, freshmen coming to campus for the first time, non-traditional sophomores coming to campus for the first time, transfer students coming into a new space, that number of sexual assaults were intensified by the number of new students arriving at college campuses across the country. Also, they were coming from the lack of resources and things that they had right before the schools had closed. So what we saw is students standing up against the way their campuses were handling sexual assaults across the country. Our partners, called the Crowd Counting Consortium, a group at Harvard, had tracked over more than 400 protests in this past school year alone across the country. Additionally, we joined with a coalition of other organizations to launch the Ed Act Now, a campaign and petition signed by more than 55,000 students, parents, lawyers, and advocates calling on the U.S. Department of Education to restore student survivors' rights and make college campuses safer by acting now to change the Title IX regulations. And that was back in October of 2021. Finally, what we know is that this past Thursday, on the 50th anniversary of Title IX, the department released its proposed rule and initiated a new notice of proposed rulemaking, also called the NPRM process, to amend the rule. The NPRM is also known as the notice and comment period, and it's the process for the public to give feedback and offer changes to proposed regulations before those regulations become official law. So the department announced the NPRM period is going to last for 60 days. And it actually has not officially started yet, but we will notify you and all of our followers via email and social media when it does. If there are parts of that proposed rule that you disagree with, you can offer comments on the proposed rule by submitting critiques about specific parts of the rule, offer data to back up those critiques, and offer alternatives. Once that comment period ends, the Department of Education sorts the comments into two groups: substantive, which means the comments that offer data and those alternatives, and non-substantive comments, which are comments that do the complete opposite. So the department is required to respond to those substantive comments. And what we also know is that those substantive comments can slow down the process of these rules becoming law. That's why what we're getting ready to do is we're planning to submit a sign-on comment with our coalition partners that you can join to help us speed up the process to ensure that we have a new rule within the next academic year. This is an incredible opportunity to take action and protect survivors' access to education. So now with that, we're going to continue our program, and I'll pass it on to Tracy, who will provide a solid breakdown of the Title IX regulations.
Thanks so much, Kenyora. Hey, everyone. Thank you all so much for joining us today. And Kenyora, thanks for kicking off the town hall. To everyone who's here, I know we have been facing an incredibly scary time in our country, and I hope that all of you are doing your best to stay safe during this really, really difficult moment in our nation's history. For those of you who I have not met yet on this call, I'm Tracy Vichers, the Executive Director of It's On Us. On the front end of what I'm about to share is that I do want to say that the goal of running through the proposed regulations is to help explain in plain language what has happened, what's currently happening, and what students can expect from the Department of Education on Title IX reform. We recognize that the inner workings of the federal government are incredibly complex and can sometimes be really difficult to understand. We also don't believe that students should have to give themselves a crash course in civics or federal civil rights law to understand what the regulation means or how they can meaningfully engage in the Title IX process. So with that, I'm going to walk us through the proposed rule changes to Title IX that were issued on Thursday and what they mean practically for survivors, students, and administrators. Please note that the entire document published by the Department of Education is more than 700 pages long. So I'm going to go through some top lines, but there is a ton of nuance within the document. I also want to stress that these are proposed changes and that the Trump era regulations are and still will be in place for months to come. The It's On Us team is working to pull together resources that we can share with students to help them understand sort of what this means for them. And after I walk through what's in the proposed rules, we've been joined by my colleague, Sylvia from It's On Us, who will walk through what students can kind of do in this interim period between with the current regs still being in place, but the proposed regs being put forward. After I run through the proposed rule changes, we will also have time to answer any questions you might have. So as they come up, please drop your questions in the chat and we will do our best to answer them in the order that we receive them at the end of the call. So now to dig into the regulations. So the proposed regulations would first and foremost prohibit all forms of sex discrimination. And this includes discrimination based on sex stereotypes, sex characteristics, pregnancy or pregnancy-related conditions, sexual orientation, and gender identity. I want to note that this is a far more inclusive definition of sex discrimination than in the current regulation, and it would help to ensure critical protections for the LGBTQIA+ community and pregnant and parenting students that we have not seen before underneath Title IX regulations. So I am very happy that we have a much more inclusive discrimination, a more inclusive definition of sex discrimination in the proposed regulation. The other thing that's really important to know is that the proposed regulations would define sex-based harassment as including sexual harassment based on sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity, and other sex-based conduct such as other sexual harassment-based conduct such as quid pro quo harassment. Again, this is making sort of the things that are covered by Title IX, those actions and behaviors that are harmful, far more inclusive for students on campus, which is really, really good. This will allow students who may be experiencing harassment because they're transitioning to be able to employ Title IX to help them through that process and to get justice for the harm that's been committed to them. So that's just one example, but there are many examples here that we could go into. The other really key piece of the proposed regulation that I want to mention at the top is that it restores the definition of sex-based harassment to one that creates a hostile environment, which undoes the harmful and strict definition that's currently in place. Under the current regulations, a student has to experience harassment that is severe, pervasive, and objectively offensive. Whereas under the proposed rule, the Biden administration is returning to the longstanding definition of sexual harassment, which is severe, pervasive, or objectively offensive. The simple difference between and or is critical here, because under the current regulation, we've seen students have to experience often ongoing and escalating acts of sexual harassment or violence, even before the school feels that they have to do any action to stop it. Whereas under the proposed regulations, we would return to a definition that one incident of sex-based harassment is enough for schools to have to take action. And that is really critical because no student should have to experience ongoing and multiple incidents of sex-based harassment while they're also trying to continue their education. Additionally, something that we're really excited about is that under the proposed regulation, schools would be required to address a sex-based hostile environment in its education program or activity, including when sex-based harassment contributes to the hostile environment in an incident that occurs outside the school's education program or activity or outside of the United States. This is really important because underneath the current regulation, schools are only responsible for addressing any kind of sex-based harassment that occurs within school sanctioned activities or programs. And for a very practical example of how this is harmful is that, at some point during their time on campus, 85% of students live off campus. And so if someone is sexually assaulted in their off-campus apartment by a fellow classmate, the school technically doesn't have to do anything about that, which is deeply problematic because that student is still having to go to class, still go to campus, still see this person, and still have had harm committed against them. So the fact that the proposed regulations return us to what had been the long-standing evidence-based best practice that any incident that occurs like even outside of the school's education program activity, the school's responsible for addressing that, which we're really happy to see that. We're also really happy to see the fact that this under the proposed regulations, it would expand Title IX protections to study abroad programs for the first time, and really restore the school's response and really make sure that if a student experiences sexual harm while they're studying abroad, that they can turn to their school for support afterwards. I also do want to share that under the proposed regulations, schools would be required to take prompt and effective action to end any prohibited sex discrimination that has occurred within its education program activity, prevent it from happening again, and also remedy effects. This restores schools' responsibilities back to their pre-DeVos era requirements, because under the current regulations, schools are only obligated to investigate incidents that they have quote unquote actual knowledge of, and in the college and university setting. And that also means that in the college and university setting, currently, it only applies to employees who have authority to institute corrective measures. So that means students would have to go to and figure out who the right person is under the DeVos era regulations to report what happened to them, and then hope that then they would take some kind of action to remedy it. But this really goes back to what, again, were evidence-based best practices that were in place prior to the DeVos era regulations that held schools responsible to act promptly to make sure that incidents didn't continue to happen, and that any kind of impact that sexual violence or harassment had on the student is remedied. So for example, if a student needs to retake a test, this would empower survivors to ask for that once they've reported that they, experienced sexual assault. The next day they went in and had to take their bio exam, and then they failed it because, of course, you've experienced significant trauma. That's a very real thing that could happen. And so this is really important that student survivors will be able to actually be able to hold their institutions accountable once again for taking action when sexual assault's taken place. The other piece that's really critical here is that the proposed regulations would also establish very clear requirements for schools to conduct a reliable, prompt, and impartial investigation of all sex discrimination complaints, including sexual violence. Right now, the current regulation requirements, again, only cover formal complaints of sexual harassment. So this would make a much more expansive policy for schools to have to take action. Something that we also do want to flag as part of the new proposed regulations and grievance procedures is that under the proposed regulations, schools must treat complainants or survivors and respondents, alleged perpetrators, equitably. The school's grievance procedures have to give the parties an equal opportunity to prevent relevant evidence and respond to the relevant evidence of the other parties involved. And additionally, the school's decision makers have to evaluate each party's evidence. The proposed regulations would also not require a live hearing for evaluating evidence, but would allow for schools to have a process for a decision maker to assess the credibility of the parties and witnesses through any kind of live questions that may need to be done by a decision maker. So essentially, what this means is that under the DeVos era regulations, schools are required to have live hearings. And we know that live hearing component of the in-place regulations has actually pushed a lot of student survivors out of the process. They report their incident meets the very strict definition of sex-based harassment under the current regulations. And then they find out that they have to have a live hearing, either in person or via technology, where the person who they have experienced sexual harm from is present. And that deters a lot of students from remaining in the process. We've heard countless stories of students hearing that and just exiting the process. So the fact that the schools would not be required to have live hearings anymore is really good, and will actually, I think, keep more survivors in the process and be able to seek the justice that they so deserve. The other really important part is that the proposed regulations would also not require cross-examination. The cross-examination component has been exceptionally controversial in the current regulations. The fact that it's live cross-examination in the current regulations that is conducted by a student's advisor of choice has also come under fire quite a bit. And so the fact that underneath the proposed regs, schools would not be required to hold live cross-examination, again, we believe will help more student survivors stay in the process of having a Title IX investigation complete. I do want to flag, though, that under the proposed regulations, schools are permitted to use permitted to use cross-examination if they either choose to or is required by law, because we have seen some states move to make this a requirement in state law. So that is just something that we need to flag there. Another really big change that is being proposed underneath the current regulations is related to the evidentiary standard. So underneath the DeVos era regulations, schools can choose between either a preponderance of the evidence standard or a clear and convincing standard. A preponderance of the evidence standard is the standard used for basically every other kind of student misconduct investigation, because ultimately that's what a Title IX investigation is. It's an investigation to student misconduct. Under the DeVos regulation, schools can choose to stick with that, which is, again, the evidence-based best standard, or use a clear and convincing standard. And so this has created a patchwork right across the country of some students having a preponderance of evidence versus some having clear and convincing. This has also made it really confusing for students who are like, wait, but if my buddy gets into a fight and there's an investigation into an act of other kinds of physical assault, they're being held to preponderance of the evidence standard, whereas my incident of sexual assault is being held to a clear and convincing standard. Like, how is that fair? And so we've seen this come up again over and over. And so we're happy to see that the regulations are really trying to help schools return to using that preponderance of evidence standard. It is really important to note that the schools underneath the current reg can continue to use clear and convincing as their evidentiary standard if they also use that as the standard of proof in all other comparable misconduct investigations and proceedings, including other discrimination complaints. So again, if the school is using clear and convincing for all their kinds of student misconduct, including discrimination complaints, they can still use clear and convincing moving forward. But our expectation is most schools are not using that as the standard for the vast majority of student misconduct that they're investigating. And so most schools will return to a preponderance of the evidence standard. The other piece that is important is that the regulation really calls out that schools are not permitted to impose disciplinary sanctions under Title IX on any person until there has been a formal determination that sex discrimination has occurred. And I'll talk a little bit more about this in a bit, but just know that that is something that is a cause for that we're trying to sort through some questions that we have about that piece. Additionally, schools under the proposed regulations will still have the option to offer an informal resolution for resolving sexual discrimination and harassment complaints. Title IX coordinators, investigators, decision makers, and facilitators of any kind of informal resolution process must not have a conflict of interest or bias for or against either complainant or the respondent that would push them to try to advocate with the students involved to seek informal resolution. We have seen under the DeVos era regulation, a lot of students being pushed towards an informal resolution process for multiple reasons, but the primary one has been because the standard that students have to meet for their incident to be even considered investigatable by Title IX, we are seeing a lot of students pursue informal resolution processes instead. So that, I believe, is part of the reason why they're calling this out very specifically within the regulation, within the proposed regulation. The other piece in here too is that under the proposed regulations, schools would also be required to provide supportive measures to any and all students involved who have either brought complaints or students who have been accused of sex-based harassment. Under the proposed regulations, schools would be required to offer supportive measures as appropriate to restore or preserve a student's access to their educational programs and activities. The current regulation only requires the support when sexual harassment has taken place, rather than any form of sex discrimination. So this is really expanding who can access those supportive measures and under what circumstances, which we know is really important because being able to access supportive measures such as, again, being able to take a test, being able to have a change of housing, being able to have a change of class schedule could be the difference between a student staying in school or a student dropping out. And so no student should feel compelled to leave their educational program because they are experiencing some kind of sex-based discrimination. So again, would likely apply to students who identify as LGBTQ, pregnant and parenting students, but would also be inclusive of student survivors of sexual assault. The other piece that is really, really critical about the proposed regulations is that underneath the current regulations, so let's just be clear, under the current regulations, schools are prohibited from engaging in any kind of action that could be deemed retaliatory, but the current regs fail to determine what constitutes retaliation. And so that just kind of leaves it open for interpretation, which is concerning. So underneath the proposed regs, the department has defined retaliation and also explains the circumstances under which it can occur. So the proposed regulations would clarify that Title IX protects the person from retaliation, including peer retaliation, and that it would also define retaliation as intimidation, threats, coercion, discrimination against anyone because the person has reported possible sex discrimination, made a past sex-based discrimination complaint, et cetera. And so this would prohibit schools from taking action against a student or also an employee under its code of conduct for the purpose of intimidating, threatening, coercing, or discriminating against them. And it also would prohibit, as I said earlier, peer retaliation, which would be defined underneath the proposed regulation as retaliation by one student against another student. And it's important because under that peer retaliation piece, it also discusses if retaliation is instigated by one of the parties involved, but carried out by someone within that social network. So for example, if a student athlete is accused of sexual assault and members of that student athlete's team are engaging in what could be considered retaliatory against them, which is really important. The other piece here is that the proposed regulations would clarify that recipients must protect students and employees from discrimination based on pregnancy or related conditions. This is really the first time that Title IX is being very explicitly related to pregnant and parenting students. And it would also, and the proposed reg would also expect schools to provide reasonable modifications for students to be able to access class. They would also the proposed reg would also modernize and clarify Title IX's longstanding prohibition against treating students or parents differently on the basis of sex, including by defining parental status to include also adoptive or step parents or legal guardians. So really excited about how expansive the new policy is, and also the fact that it really returns us to longstanding evidence-based best practices for how Title IX should be applied to issues of sex-based harassment and discrimination. But we also do want to call out a few pieces that are not addressed by the proposed regulation that we have concerns about, or if they are addressed, they're not addressed to the degree that we would like them to be. So for example, one of the key areas that we have concerns about is that the proposed regulations do not address the religious exemption clause of the current rule, which permits institutions to claim a religious exemption from Title IX without notifying their campus community that they have done so. This is of concern to our organizations, and we're really hoping to be able to address that in our comment. We are also concerned that the proposed regulations do not adequately address the difference between restrictive versus disciplinary measures and the impact a lack of clarity can have on students seeking no contact directives from their institutions and on their professors, coaches, staff, and others who may want to play a role in supporting students in their educational experience at school. Essentially, a restrictive measure can be sort of broadly considered as the two students have a mutual no contact directive, right? But then a disciplinary measure would be something in the most extreme form, like suspension or expulsion. Whereas there's a lot of gray area around like what is restrictive versus disciplinary. And one place that we have seen this play out pretty clearly has been within sports at school. So for example, if there's an incident of sexual violence that takes place between a member of the men's swim team or the women's swim team, and the student survivor wants to pursue some kind of restrictive measure, such as a no contact directive, but there really aren't any other options for practice because the school only has one pool and they only have access to practice at the same time every day. How does the coach and how does the school address that? And how could something that might be a restrictive measure then be interpreted as a disciplinary measure in that period of time if, say, the student who is the respondent is then told that they can't practice and play? And that feels like a weird gray area that we're hoping that we can resolve through the comment process. We also are concerned that there was a decision made to conduct a separate NPRM to address whether and how the department should amend Title IX to address students' eligibility to participate in sports, particularly trans student athletes. So originally we were operating under the information that we thought that the Title IX regulation would be addressing trans youth in sports, but the department announced at the time that they issued this regulation that they're actually separating that out, and that will be its own NPRM process. So we're still trying to figure out why that happened, but right now there's lack of clarity on that, and we do believe that trans youth should be able to participate in sports, and so hoping to get more clarity on that. And, also while this is not the massive 2,000-page document that was put out by the last administration, we are still learning more about the regulation. We're going to be having lots of conversations internally as it's on us in EROC and also with our advocacy partners in the field, and with just student survivors in particular, wanting to get reactions from them about how they feel about these regulatory changes, if they have questions or concerns, so that way we can make sure that those are getting raised in the joint comment that we will be submitting as part of the comment period. Now, just briefly before we open to Q&A, I'm going to turn over to my colleague, Sylvia. She is going to share some information on what students can do and expect during this period while the Trump regulation is still in place and the new regulations are enacted. So Sylvia, I will let you take it from here.
Hey everyone, thanks so much, Tracy and Kenyora. Hi, my name is Sylvia and I am the Senior Director of Education and Research here at It's On Us. So right now, after hearing all of that, you may be wondering, well, what can we do in the interim? So between now and when the new regulations actually go into effect, I do want to say that one of our demands to the Department of Education is currently to issue a non-enforcement directive on the existing rules to help students that have and will continue for the next year or so of this process to report under the DeVos rules. So unfortunately, this has not been done yet, and it's very possible that they will not put this into effect. The legal team at Ed may not allow it because of several reasons, but unfortunately, this is the law of the land right now. However, we do have a couple of options for ways to ensure that the current rules do the least harm. So the Office of Civil Rights has and will continue to issue rulings on cases that we can use to guide our schools in how to do the least harm. So these cases and guidance documents are on the Department of Ed OCR website, and we will share that in our notes afterwards. But some of the main points that are there right now, and again, they're going to continue to add to this. They have a document that's specifically on sex discrimination as protecting gender identity and sexual orientation. They issued guidance that applies the 2020 SCOTUS ruling, Bostock v. Clayton County, which rules that sex discrimination does constitute gender identity and sexual orientation. So that ruling vacates the DeVos judgment that trans students and queer students are not protected by Title IX. They also have a document that says, that's specifically on live cross-examination, that vacates the ruling that prohibits decision makers in Title IX proceedings at post-secondary institutions from considering any statement from a person who did not submit to cross-examination at the live hearing. And then they also have, and this is one of the first documents that they did release, they have a Q&A appendix, and this provides a lot of interpretations on the DeVos rule that may allow for more protections for students. And again, these documents are going to be really helpful to fill the spaces that your schools may not already know exist in order to make these rules less harmful. So we will be working with our coalition partners to monitor new precedents that may be helpful to survivors and provide easily accessible information about ways to talk to your schools about this. So please look out for information. We are going to be posting all of it on our Title IX website, which Kenyora will be plugging for all of you a little bit later in this webinar. And last but not least, another way that we can push to change for change in the interim is by encouraging the submission of Title IX complaints to the Department of Education. So I know that during the DeVos era, we did not encourage this because it was unlikely that the complaints would ever be processed. However, now we need to send them in to really communicate to the department that there is a high need for additional staff so that they do review and respond to all of our complaints. And again, more to come on both very soon. And please, everyone, take care of yourselves. I will pass it back to Tracy and Kenyora.
Thank you, Tracy and Sylvia. I would say let's do some questions before I get into some of the actions.
So just to clarify for folks, what came out on Thursday, because this has come up a couple times in the chat, they're proposed regulations, which is why it's really important to be participating in the comment process, to show support, to offer alternatives to things that you might find concerning about the draft regulation, and that ultimately from here, which Kenyora mentioned at the top of the call, what will happen is we will have a 60-day public comment period. After that 60-day public comment period closes, the department is responsible for reading and responding to all substantive comments. So that means they're backed up with data, they have facts, et cetera, associated with them. Just submitting, I don't like it, doesn't count. It just for clarity. And so they'll be responsible to read and respond to all substantive comments. That process, just for full transparency, can take months, depending on the number of comments submitted. So for example, because there were so many comments submitted on the DeVos era regulations, as Kenyora noted, over 120,000, it took almost 18 months for a new regulation to be put forward. And that's really important to note, because in our case, we want to see the bulk of this regulation move forward. We obviously have some concerns that we want to raise with the Department of Ed, but for the most part, we are very supportive of the existing comments, or of the existing proposed regulation. And so that's why we are encouraging folks to join on to sign on comments that are substantive, rather than flooding the department with a lot of comments. So that's just something to flag here, is that these are draft, they are not final, and that after that review period, then the department will issue some kind of determination about how they're moving forward with the regs and when the new regulations would go into effect. Typically, schools are given around 90 to 120 days. And that will then give schools the time to change their policies, procedures, et cetera. So that's just a quick flag on that, because I know that's very confusing about current regulations, proposed regulations, the timeline. It's a lot to keep track of.
Also, I see a question. So I did answer some questions in the chat as Tracy was giving some overview, and Sylvia was giving overview as well. But one particular question that comes up was around mandated reporting. And so they do, in the proposed, again, these are proposed regulations, they do talk about confidential employees, especially those who are privileged under federal and state law. So for example, like physicians and like your doctor and your clergy would be considered confidential employees. What they do have is that if you are like a campus administrator, a coach, like, you know, basically an employee at the school, what you are obligated to do at the very least is provide a student or a person who came forward to disclose what happened to them, information on the Title IX coordinator, as well as how to contact that Title IX coordinator and how to report to that Title IX coordinator. But as of right now, it's not saying that there's an obligation made by, well, actually, I would change that and say, schools actually put on notice in the sense that something happened. And so essentially, at the very basis, that school employee has to provide that information to the person, the student who disclosed. But I think, and Tracy, please step in here, I haven't seen anything that says that that person then has to go to the Title IX coordinator or designated authority to state that this is what's going on. I will say that this is different than if someone were to is dealing with suicidal ideation or anything of that nature. So that's two separate things, which is unfortunate, but there's that clarification that is needed there.
Yeah. So just to build on that, and this will also answer some of the questions in the chat. So there are certain protections here that only affect university and college institutions. Those are the changes that we spoke about here today. There are other proposed changes or modifications to the reg that are applied in the K-12 setting. So for example, in the K-12 setting, parents or legal guardians can make a report on behalf of their child in the proposed regulations, which was not the case under the DeVos era reg. So there are some changes that are very specific to K-12. We here are talking specifically about college and university settings, so undergrad and graduate student programs. And there will be resources put out on the K-12 provisions. So we will be able to make sure that those things are shared with folks as there's more clarity and more resources being developed for how this would impact K-12. Additionally, Kenyora sort of touched on this a little bit about mandated reporting. So under the proposed regulations, there's a lot more clarity around who is and who is not a mandated reporter and who has privilege, because there was a lack of clarity on that under the current regs of who has privilege, who doesn't, under what circumstances is there privilege, et cetera, versus who's a mandated reporter. We also know that there has been a lot of concern and confusion underneath the existing regulations around students who are both students but also employees, such as RAs, because in many cases students might turn to their RA as a person for support, but then that person is also considered an employee, not just a student, and then they have mandated reporting. So the current reg is trying to really clarify who actually is a mandated reporter and under what circumstances are they required to report and what information are they required to report to the school. So there is quite a bit in there around the very specific pieces for that. And then I know, Ms. Shirley, you'd asked about schools required to report under the Clery Act. Yes, schools are required to report aggregate data under the Clery Act. But those have to be official reports that are submitted to them. So those have to be reports that they've done some kind of intake on. That's either been reported to the Title IX office, campus security. Informal reports are often not included in those numbers. And we also know that the vast majority of student survivors don't report their sexual assault. Only about 10% of student survivors actually report to their school. So Clery numbers are actually not a really good reflection of the incidents on college campuses. And my rule of thumb is always, if less than 10% of survivors report, take what's in your Clery numbers and multiply it by at least 10. And that would be an actually more accurate reflection of the severity of the incidents of sexual assault happening within a campus community. Do we have other questions? Well, if other questions do come up, you can, if you have this sites, yes, we do have that. We can share out all of the information regarding citations, the policies or the proposed regulations, the summary doc, the proposed regulations. We're happy to share that out via email with folks who have joined us here today. And with that, Kenyora, I will turn it back to you to wrap us up.
Awesome. Thank you all. And again, if there are any questions that continue to come in, please feel free to send in to us. We will be sure to follow up also via email with some of the questions that have been raised. So that way, when you have a document essentially that has all of these answers in there. As we move forward into the next kind of segment in terms of our calls to action, as we stated at the top of the call, we are preparing to submit our comments through the NPRM process with our coalition partners. And so as we get that letter prepared and ready for folks to read and to hopefully sign on to, please visit the civicnation.org/Title IX website. On that site, you can sign up where you'll be able to hear firsthand from us about what that letter will entail, what that looks like, and then you can sign your name when you're ready. I would also want to say that This should not prevent you from submitting your own comment. However, we are trying to get as many folks to sign on to our letter as possible, so that way we can speed up the process in terms of a finalized rule. If you're looking to start a chapter at your college, our great partners at It's On Us can help you get started. And here's the link if you're looking to do that on your respective campus and starting a chapter there. And if you are a survivor and may stem from a historically marginalized community, and you want to engage in somehow in some way, especially in this upcoming academic year, NRAPE on campus has a student survivor caucus that we would love for you to partake in. And if that's something of preference, please feel free to learn more, and we'll be sharing more information on how to get involved once the application is set and ready to go. With that, we hope today's Title IX Hall has been truly a helpful one. Please be on the lookout for more information in the coming weeks. And again, as I mentioned, if we was not able to get to your question yet, it's simply because we're still learning more through the NPRM, about the NPRM processes, as well as what's written in the current proposed rules. And so we want to make sure that we're providing you with the best answers as much as possible. So we'll save your answers and provide and follow up with you in the coming days. But please take care of yourselves during what has been I don't even know how to describe this past week. I know some of you all might still be as frustrated as we are. And so please take care of yourselves and engage in as much self-preservation as you can. So with that, we hope you have a great rest of your afternoon, and thank you so much for joining us. Thank you.